morning. It's still morning, Miss Meach. How long do you think you're going to be on this point?
My Lord, depending on the questions asked, I would anticipate around 30 minutes.
Okay, not longer than 30 minutes, I think. I think we're pretty familiar with the cases in this area.
I'm grateful. Yes. I'm grateful for that indication, and I hope that will allow me to take my submissions as shortly as possible. So, my Lords, my Lady, in our submission, Section 3 of the Human Rights Act 1998 requires that this court rejects the appellant's interpretation of the rules, even if, on ordinary interpretive principles, they would otherwise be preferred. I ought to say that my submissions are irrelevant if your Lordships and your Ladyship reject those constructions on ordinary interpretive principles, as we say you ought to do for the reasons that my learned leader has set out.
So we are assuming, are we, that Mr. Stewart's right?
We are.
On what? On point one or any of them?
I'll have to address each of them, my Lord.
Okay.
Most of my points are relevant to each of the constructions.
Right.
So Section 3 requires that legislation be given a convention-compliant meaning wherever possible, subject only to the modified meaning remaining consistent with the fundamental features of the legislative scheme. That is Gaydon and Godin Mendoza, the House of Lords decision from 2005, which this court is likely to be familiar with. I can deal with it if needs be, but I will do so at the end of my submissions. The relevant convention right in this case is Article 6, and in particular, the right of access to justice and the right to equality of arms. To deny these claimants and other claimants litigating at the moment and future claimants the ability to issue a single claim form, have one set of proceedings, and all the advantages that that brings would, we say, infringe their Article 6 rights. We deal with this element of our submissions at paragraph 65 to 82 of our skeleton argument, which is pages 42 to 47 of the bundle. By the court's leave, I intend to divide my submissions into 4 sections. First, the consequences of the appellant's construction for our clients and more broadly. Second, why we say those consequences would infringe Article 6 rights, and I'll deal there with Steele and Unison, taking those briefly. Third, if necessary, I'll address the court on how Section 3 operates. I imagine that won't be necessary. And fourth, I'll deal briefly with the observations made in the appellant's supplemental skeleton about the ECHR points. Yeah. Turning first to the consequences of the appellant's construction. There are various types of consequence that need to be addressed. Financial consequences, representation consequences, and limitation consequences. Before I come on to those consequences, it's useful to focus on what the appellant must be saying ought to happen in this case and these sorts of cases. And that is at least 96 claim forms. Almost all of them will be under the High Court limit, so they'll be issued in the county court. And if the appellant's position is that a common issue whose trial won't be helpful, then it must also be their position that they shouldn't be heard together at any point. So the position must be 96 claim forms, 96 sets of pleadings, and so on down to 96 county court trials. The financial consequences of that construction is that it deprives the claimants of the financial benefits of group litigation that have developed over the last few decades. And Mr. Niven, David Niven, who gives evidence, which is in the bundle, of Pennington's Manchys Cooper, says in his witness statement that the claimants join together because it's uneconomic for them to litigate alone. And for your Lordship and your Ladyship's reference, that's page 24 of the supplemental bundle at paragraph 29. Indeed, that was identified as an issue in 1991 in the guide, which is in the bundle. And rather than take your lordships and your ladyship to the guide, I'll say what it says and give you the reference if that works. What it says at page 410 of the authorities bundle is it's a feature of most group litigation that the potential costs for the individual are so high that whether the potential damages be great or small, the cost burden creates a real obstacle which may bar the individual from pursuing a claim. Cooperation with other complainants is frequently required to overcome that obstacle. Now, in case there's any doubt, the guide advocates very strongly for everybody joining together on one writ in one action. So either in one writ to start with, or everything being consolidated as soon as possible. And consolidated meaning collapsing into one action rather than just being heard together. And in particular, the reference to one action is at page 407 of the authorities bundle, but it's clear throughout the guide. Yesterday, my learned leader, Mr. Johnson, said that the only sensible thing would be, once they issued on their own claim forms, is for them to be heard together as soon as possible and dealt with on sort of parallel tracks. But if the claimants don't have common representation, as they won't have, I'll come on to that, who is going to propose that? It relies on court staff spotting that there are lots of similar claims coming in, and a judge ordering of their own volition that they be heard together.
I think, if I may say so, you're attributing too many consequences to the rather narrow point Mr. Stewart's taking, which is about the contents of a single claim form. Don't think, for instance, he says that if 96 claim forms had to be issued, you couldn't have the same solicitors and counsel. Indeed, he refers to Lewison Daily Telegraph, which suggests you do have to. Nor, I think, does he suggest that if 96 claim forms were issued in the county court, it would be impossible to have a GLO, so they could be managed together and common issues identified and dealt with.
My lord, on the solicitor's point, I rely on the evidence that we put in that Penningtons wouldn't be in a position to represent them individually, so I'll come on to that in a moment. On the GLO point, I hadn't understood that Mr. Stewart accepted these could be dealt with as a GLO, because that assumes that they have common issues of law or fact. So he wasn't asked yesterday what the consequences were of his construction, but in my submission the only natural consequence is 96 sets of proceedings running through to trial.
But how do the factual consequences of this particular case affect really the application of Article 6 and Section 3 to a situation of this kind when you're considering the construction of a fairly simple rule? I mean, if the rule clearly stated, let's say the rule clearly stated, every writ must be issued. Let's say it was done for financial reasons. The Ministry of Justice, short of cash, said group actions now have to pay £10,000 per participant. Then I suppose you would say you had a case, would you, on sort of unison grounds?
Yes. So what the legislation says at the moment is that the £10,000 is payable on starting proceedings, and that's referred to in paragraph 78 of our skeleton argument.
Yeah.
It's the CPR which determines who is entitled to start proceedings together, and so it's those rules that we're interpreting, and those rules that I say Section 3 means that if your lordships are going to, and your ladyship are going to take that narrow view proposed by the appellants, then Section 3 requires that the court look at the real world consequences of that, and that comes from unison, and remembers that the convention is intended to protect real and effective rights, not theoretical rights.
But I mean, you can assume, without telling us about this action, that the idea that they should all issue claim forms and pay £10,000 is a loony idea. You know, you hardly need to. I mean, well, it's even more loony if it was Mariana. So, and actually, the logical extreme of their argument, despite their concession that Mariana is allowable, on their interpretation, it's not.
So
And not unless you read in lovely words that Mr. Stewart's prepared to accept for reasons I haven't yet worked out, but he's going to tell me in reply, I'm sure.
My lord, I certainly wouldn't demur from that. And Mariana, even if they were to pay only £35 each, would amount to over 25 million in fees if they had to issue.
Well, I'm sure that's very good for the Ministry of Justice, and they'll be delighted.
So, in my submission, the financial consequences of having to each issue a claim form, and it wouldn't be £10,000 each here, it would be £5,000 or less here, because they're less than £100,000 each.
You still, the point's the same.
It would total around £500,000 in fees. That's Mr. Niven's statement, page 25 of the supplemental bundle. There is some querying of that £500,000, but my point is the same whether it's 100,000 or 500,000 to start this one action. Just on court fees, before I move on, sharing court fees is an entirely legitimate benefit of litigating as a group, and that was said in the guide when it said to issue one writ on behalf of 1,001 plaintiffs instead of one writ on behalf of each of those plaintiffs provides a saving of 70,000 in court fees for the writ alone, and a further saving of at least £10,000 for each interlocutory summons later issued. And for the court's note, that's page 420 of the authorities bundle. And the question is, why would a rational defendant want more court fees to be paid? Because if they lose the litigation, they'll be liable for adverse costs, including the court fees. Why make that figure larger? And we say that's because they hope that it will be infringe the rights of access to justice, and I'll come on to what the evidence we have here is. So on financial costs, it is court fees, but it's also not being able to share your own costs. And Mr. Niven says that the majority of costs in litigation, such as the instant case, are common costs. And that's page 25 of the supplemental bundle, paragraph 31(2). It is also not being able to group together and have an order that you're only severally liable for adverse costs. So as your lordships, your ladyship may have seen, it's very common when you have group litigation to get an order that you're liable severally for a figure related to the adverse costs as your own claim related to the totality of the claims of the claimant. And if the court needs an example of that, there is one in the supplementary bundle at pages 58 to 69. We have the order in Spence, which is a fraud claim by many claimants against a number of defendants. The final financial consequence that I would refer to is not being able to litigate together would mean no after the event insurance. At least our after the event insurers have told us that ATE insurance would not be available to individual litigants. And that's page 26 of the supplemental bundle, paragraph 31(4). That, of course, is more than a mere financial consequence, because corporate claimants or individuals overseas might face a security for costs application, and were they not able to find the money or a suitable bank guarantee, they might have their claims struck out. So those are the financial consequences. Next is the representation consequences. And Mr. Niven's evidence is that over the years, he's had conduct of many cases on behalf of investors who've made claims against solicitors for breach of duty arising out of a failure to give proper advice in connection with off-plan purchases of units and properties such as those in the present case. The obvious example is Jambroni, which ran through and then was in the Court of Appeal. He and his firm are experienced in this kind of litigation, and they are well resourced. And Mr. Niven says that Penningtons would not be in a position to represent the claimants individually. And that's at paragraph 31, sub 6. Turning then to the limitation consequences. These points are made without conceding there would be a limitation defence in any of these claims, but 26 claimants in July last year and more now are more than 6 years on from loss. It may be that an order like that of Master Davison in Abbott 1 deeming issuance to have taken place on a certain date could save these claimants. But what about future claimants? If the court thinks particularly about the 3-year limit in personal injury claims, if you're acting for 3,500 people or 720,000 people, which is the Mariana case, then issuing the claim forms is going to eat significantly into your 3-year period of limitation. And also, since issuing a claim is meant to be the last resort, if pre-action settlement isn't possible, it eats into time that could be better spent.
I mean, again, this is obvious.
This is obvious, my lord, but these are the consequences of the appellant's reading of the rules.
Yeah. So perhaps move on to your second head.
So those are the consequences, the theoretical consequences, but just very briefly, these actual respondents. Only 77 of the clients who responded to Mr. Niven's question as to whether they would continue, if required, to pay a £5,000 claim fee and had no CFA or ATE cover, only 2 of them said that they would continue. So that evidence is at page 130 of the supplementary bundle, paragraphs 6 to 7. Now that evidence is criticised as not being a large survey of hundreds of people, but nevertheless there is evidence here that these respondents wouldn't continue if required in those circumstances. So why are those consequences an infringement of convention rights? We concentrate on 2 particular points: representation and access to the courts. I'm grateful for the indication that the court is familiar with the authorities. The point that I take from Steele is set out quite clearly in the head note, which is at page 249 of the bundle. And if I could invite your lordship and your ladyship either to read paragraphs 1 to 5 of the head note, or perhaps to note it. The key points are, as I've said, that the convention was intended to guarantee practical and effective rights.
Yes, well, we're pretty familiar with that, yes.
So, my lord, we're not arguing that the state should fund our clients' claims against their negligent solicitors. The time when group litigants could access legal aid, which was clearly the case when the guide was written, is now over. But we say that the market has developed a method of achieving equality of arms for the respondents and other similar group claimants, and that the appellant's construction would deny that route to equality of arms and is therefore in breach of the convention.
Yeah.
Turning then to court fees and the Unison case, I'm sure that your lordship and your ladyship are very familiar with this case. I would take you to one section in particular of the judgment, which is at page 332 of the authorities bundle, behind tab 15.
Which paragraph?
332.
No, I don't think it can be. 132.
Paragraph.
Paragraph 17, is it?
It's paragraph 17, yes.
Thank you.
Just to highlight there at 17 and 18 that the fees order for the Employment Tribunal and the Employment Appeals Tribunal set different fees for individuals and for groups.
Yes.
So it's perfectly possible for a fees order to do that. And a quick calculation shows that it is cheaper to litigate as a group, to issue as a group, than to issue as an individual. So 200 claimants with a type A claim pay £11.70 compared to £390, and type B £36 as against £1,200. So it's perfectly possible. It's not the case here. The wording is on starting proceedings. The only this case wasn't a challenge under the Human Rights Act, because Unison aren't a victim within the meaning of Section 7. But nevertheless, it did consider convention authority, and without taking your lordships and your ladyship through it, it talks about the importance of access to the court in upholding the rule of law. It refers to the fact that a barrier to bringing proceedings isn't the only thing which can interfere with rights. That's paragraph 78. It refers to where a statutory power authorises an intrusion upon the right of access to the courts, it's interpreted as authorising only such a degree of intrusion as is reasonably necessary. That's paragraph 80. It refers to the proportionality requirement of ECHR law. And at 112, paragraph 112 on page 356, however, under the Convention and under EU law, the ability to pay fees is not determinative of their proportionality, it's merely one amongst a number of factors. It also emphasises, and I'm taking this quite quickly, that
Yes.
the protection of rights required is not... The Strasbourg Court makes it clear that the protection of rights which are not theoretical and illusory but practical and effective, and that's paragraph 109. Unison was decided, in fact, on common law principles rather than resorting to EU law or ECHR law. But there are references in there to convention rights. We say then that Steele makes clear that the convention rights require equality of arms if possible, and the appellant's reading would take away our route to equality, and that court fees are a fetter on access to courts, and limitations must be proportionate. And we say that £500,000 for our clients isn't proportionate. I assume I don't need to take the court to Gaydon and Godin Mendoza and explain how Section 3 applies, but we say it's applicable here if the appellant's interpretation is otherwise, either of the appellant's interpretations are otherwise preferred. And then turning to the appellant's observations in their supplemental skeleton. They say, first, payment of separate court fees should logically lead to an overall decrease in the level of such fees to the benefit of parties. That is, as Lord Reed says at paragraph 100 of Unison, it's elementary economics and plain common sense that the revenue derived from the supply of services is not maximised by maximising the price. And of course, it only leads to lessening the fees if it costs the system less. And what's being proposed is 96 sets of proceedings through to trial. The second point they make is no rational ground for the claimant who is able to join with others paying a lower fee. In my submission, that's entirely the rational position. What we say is, if you're thinking of the courts as a service and claimants as service users, which of course is language that the Supreme Court abhors, it of course makes sense, because if you've got one set of proceedings, you have one set of pleadings that need to be filed, you have judicial time for one CMC, possibly more, but no more than any other complex commercial litigation. And if there have to be individual trials following the generic issue trial, then more hearing fees are payable in any event. So the third point is that the setting of court fees can't affect the construction of the CPR. We say that the high fees from 2015 certainly bring it into sharp focus.
So you say that Abbott is wrong, say that it doesn't, that the fees order doesn't affect
The
the
ECHR points weren't argued in Abbott. So the relevance of the fees payable is relevant to my points on a Section 3 reading. That wasn't argued in Abbott.
Well, something seemed to be argued relating to the fees in Abbott. I don't know quite what, but otherwise Mr. Justice Andrew Baker wouldn't have rejected the argument.
Yes, I see that, my lord. But I say it is relevant to a Section 3 analysis. I've mentioned the guide in 1991 when the fees were £75, so that the higher fees bring it into stark relief, but it's not just that. And it said that we ought to challenge the fees order. Well, as I've said, the fees order provides that the fees are payable on starting proceedings. It's the CPR which determines who is entitled to start proceedings together. So that's what we need to challenge, if that means that only one individual can start a claim form, or if our clients can't start together. So unless I can be of any further assistance.
No, that's very helpful speech. Thank you very much. Mr. Stewart.
My lords, my lady, I want to deal with 4 propositions in relation to what I will call the main body of the appeal, and then briefly make some observations in relation to the submissions under the European Convention point. The first point in relation to, the first point I wish to make is that whichever way one looks at Abbott 2 and Abbott 3, they are fundamentally incompatible as to what they say the rules presently mean. My learned friend's principal attempt...
Sorry, they're incompatible with each other? They're incompatible with what?
They're incompatible with each other.
2 and 3?
2 and 3 are incompatible with each other.
Yeah.
My learned friend's primary attempt...
I mean, is that our problem?
Sorry, my lord, I didn't hear your question.
Is that our problem? I mean, it seems to me that Abbott 2 is what we're concerned with, and Abbott 3 is something that is nothing to do with us.
Well, my lord, my second proposition was going to be that what Abbott 3 tells you is that Abbott 2 is entirely unclear as to what the relevant matter is, which is
well,
your problem.
It may do, but ultimately we have to look at the law and not at what's going on in Abbott, because Abbott is not before us.
Well, my lord, that I do agree, but equally a decision by the divisional court as to the application of the particular rule in issue, which purports to set out guidance in relation to it, is of fairly fundamental significance, and if what is being said can't be understood, as I would say, it can't be understood even by the court in that particular case, that is fairly strong evidence in support of the proposition that I made to you yesterday, that there's quite a lot of confusion here.
Sure.
Can I just make
I don't think anybody would gainsay that there's quite a lot of confusion here.
Well,
let's hope there won't be after our judgment.
well, my lord, I'm certain there won't be. Well, can I just make good the proposition I was just in the course of making, which is under one, because and this is between Abbott 2 and Abbott 3, so that's what I'm on at the moment, which is my first proposition. My learned friend's get out of jail card for the difference between Abbott 2 and Abbott 3 was the proposition that what was being looked at was what he described as the pre-Court of Appeal, the pre-divisional court universe. That simply fails to take account.
Sorry, I didn't catch that.
The pre-divisional court universe, in other words,
yes. Yeah.
That simply fails to take account, and he didn't deal with the very last paragraph of Lord Justice Dingham's judgment in relation to that, where Lord Justice Dingham's in terms plainly dealing with the post-divisional court environment envisages a court process to look at again, if I could put it that way, the questions which arise. So in my submission, there is no answer to the proposition that Abbott 2 and Abbott 3 are fundamentally incompatible. Second proposition is the confusion which is in Abbott 2 itself. Being very charitable, there are 2 versions of the test stated. Being less charitable, there are 4 versions of the test stated. None of them, with respect to the divisional court, sorry, this is my third proposition, none of the divisional court's reasoning in Abbott 2 grapples with the real issues which are involved in making a determination of the issue of convenience, as they saw it, or the issue of claim and convenience, as I submit, at the point of issue of the claim form. Can I just illustrate what I mean by that third proposition? Your Lordships were taken this morning to the refreshing decision of Lord Justice Scrutton and his colleagues in the Payne and British Time Recorder Company back in 1921. Now, that case, on its facts, was obviously about whether you could have 2 defendants, not claimants, being joined, but the circumstances in which that was sought to be done was a perfectly straightforward one. It was either a claim that the cards which were the subject of the action were perfectly good, in which case they had to be paid for, or if that wasn't right, then the supplier was liable for the defects in the cards which were present. And therefore, what the claimant was doing, or what the plaintiff was doing, was bringing in one action alternative claims, one of which had as its premise that the cards were perfectly good and effective, and the other had as its premise that they were defective. And plainly, as the Court of Appeal found, that issue was central to both claims, and moreover, it has got to be determined for all practical purposes in the same action to avoid the possibility of inconsistent findings on the central issue in each claim. Otherwise, poor old British Time Recorder might end up failing on both grounds. And in my submission, that is all that you really need to know about the position in relation to that case. Fourth proposition,
I think part of your third proposition is that in Abbott, if you'll forgive the colloquialism, the divisional court just kicked the can down the road.
Absolutely, Morwood, and that is absolutely where I'm going with my fourth proposition. That the test put forward by the divisional court in Abbott effectively means that you can't determine sensibly the question of convenience because the necessary material upon which it's going to be supplied isn't available. And contrast that to the decision in British Time Recorder, where it's clear on the face of the claimant's own pleadings what the convenience is. You've only got to look and see these are alternative claims against either the person who's obliged to pay for the cards or the supplier of those cards. Now, just developing my fourth proposition, which my Lord anticipated. My learned friend frequently asserted, as a matter, as it were, of established fact, that it would inevitably be the case that these claims would be tried together if they were, or determined together if they were issued separately. He also asserted, as if it was a matter of established fact, that although the advice on his own pleadings was materially different, he asserted it all meant the same thing. Now, it is not before the factual matters, which are the substance of that, are not before you, because we haven't got the material. The learned friend said, well, I took my 6 best cases. The evidence which goes to that, where we identified just how disparate some of them were, is not before you for reasons which the court understands. But the point I am making is this. The assertion which my learned friend makes is a pretty bold one. You assert that you've got 9 different properties. You assert that in one of them you've got 14 different versions of advice. You can look and see at his own pleadings, and I showed you only versions 1 and 14, to show that the structure of the transaction being described is fundamentally different. You've got guarantors and so forth who are around by the time you get to version 14. You haven't got them back in version 1. And the learned friend simply asserts, as if it is a matter of established fact, well, these are, this all means the same. There are common issues here. What he hasn't done at all, and no one has done, is any kind of forensic analysis of what these common issues are and so forth. And that's because we've got this wishy-washy test of some degree of commonality or real progress being made towards determination. And there is absolutely no method at all of testing that. Now, off the back of that fourth proposition, in my submission, my learned friend makes all sorts of assumptions, but the fundamental point is that the claimant is then, or claimants are then put into the position of arrogating to themselves the decision as to whether there is commonality, without even doing the courtesy of providing the defendants with the information which would be available were we to have, as it were, standard issues. And I showed you the beginnings of the particulars of claim, where we don't get even standard disclosure because the claimants say there's more than 1,000 pages of documents. Well, of course there are more than 1,000 pages of documents because they've put together 134 different claimants. Now, in that situation, in my submission, you've got a complete difference from, for example, the position for a group action, where before and as a precondition for a group action, you have defined criteria, and the court looks itself and decides whether or not it's appropriate for these matters to go forward or not. And just going back to, if I may, the position pre-CPR, there are two relevant points which were in 15.4 and in relation to 15.4, the first is the same transaction or series of transactions. Now, plainly not same transaction. On any view, this is not the same transaction. And to assert, as my learned friend sought to do, that there is any kind of equivalence with British time recording in relation to that is my submission, misconceived. Series of transactions, well, that begs the question, frankly, are these actions related? Are they related on my learned friend's own pleadings? And that hasn't even been looked at. And so what we are then left with, in my submission, is the divisional court not being given any guidance beforehand, coming out with these series of unsatisfactory tests, but no actual decision in this case of the fundamental question. I appreciate that what that means is if I am right and this court decides that there is a materially different meaning to the meaning of either claim or convenience, and you find that I am not right on my primary submission, that leads to effectively going back to have the matter being redetermined. Because what I would say in those circumstances is that if you've got a different test which hasn't been applied, we haven't had any investigation of the underlying facts, you've simply had a series of assertions, as I put them. My Lords, those are the core points by way of reply. My Lord the Master of the Rolls, I'm not sure, sorry, I was going to say I'm not sure whether he was teasing me or not, but appeared to be inviting.
That's a fair point. People are often not sure about that. On what do you think I might have been teasing?
It seemed to me that you might have been saying that I needed to make further submissions to you in order to be clear as to what my fallback position was yesterday. That's what I took from the intervention that you made.
No, I don't think we need that,
no.
Mr. Stewart. No, I think we are probably pretty clear.
I'm grateful, my Lord.
But you do want to say something about the Human Rights Act?
Well, not particularly, but I have got a few things that are less prevented from doing so. I'm going to say, but pretty briefly.
We won't prevent you.
I'm grateful. Can I just make one point in relation to the matters which isn't in the material before you, but which did occur to me when I heard my learned friend making her submissions. One of the points that she made in response to what we said, because what we say is that this is all about the fees order, and she said, no, it's not about the fees order, as it's starting proceedings. Well, of course, the fees order in its present form has only been in place since I think it's the 9th of March of 2015. Prior to that, the maximum fee for the issue of a claim form for, I think, more than £300,000 was £1,920. I'm not quite sure how they got to £1,920, but there we are. And the fees for sums below that were materially less. It probably doesn't matter what the figures are, but for around about £100,000, you'd have been looking at a fee somewhere in the order of £1,200 or thereabouts for an individual claim. So the as it were, the real stigma at which her evidence is said to go does actually go to the fees order of the 9th of March of 2015, rather than to the rules which have been in place since 1990, none.
I mean, your point essentially is that an increase in fees can't change the pre-existing meaning of the rules.
Exactly, exactly, Michael. Precisely so. The other points which I wish to make in relation to the Human Rights Act point are really those made in our skeleton argument. But can I just expand on, I think, two of them? It's our supplemental skeleton argument, paragraphs 13 and following. The first is just a matter of maths, and that is at paragraph 23. If you look at the schedule which I waved around yesterday morning, the total claimed in these proceedings is £10,286,795 odd. As a matter of pure arithmetic, the number of person-specific claims, by which I mean those which are made individually but either solely or jointly, is on our calculation 100. So the average on that basis is 102 odd £1,000. It probably doesn't matter, but the learned friend asserted, and I don't know where she gets this from, that the claims would have been below the High Court limit, but obviously they would have been on that average just over it. And the second is that you've obviously got within that a wide variety of different investments, so that, for example, Hague Investments Limited are claiming £282,000 and so on and so forth. So that's just on the arithmetic and on the math. Perhaps more fundamentally is the criticisms that we make at paragraphs 19 as to the evidential basis for the assertions made. And in our submission, it is pretty remarkable that the sum total of this is Mr. David Niven's second witness statement. He's got 134 claimants. Of those, only 77, so only some 60%, I think a little under, have bothered to reply to the questions he's put forward to them. Of those, only 2 said they would issue a standard loan claim, and only 1 was prepared to do so. We haven't seen what the basis for all of this was, and so on and so forth, but in our submission, that is a million miles away from the sort of evidence that you would need to establish that there was a real Human Rights Act point of the sort which was being considered in unison. And in our submission, that of itself is enough to prevent it being put forward. My Lords, the other points which are made by us under the Human Rights Act are stated here. We don't resile from them, but unless there's any points which are unclear or upon which you would require further assistance, I shall take them as read.
You may take this as a tease question, Mr. Stewart, but why would any rational defendant want more court fees, since you'll be paying them in the end, if it's not just in order to dissuade these claimants from bringing these claims?
No, my Lord, that is not a tease question. That is an extremely important question, and there's a very good answer to it. The answer is that what that means is that we do not start off with an assumption that under this juggernaut of all these various disparate people who are in all sorts of different parts of the world, that we're stuck with a process where we don't get proper particulars of the details of the claim, we don't know even whether they've read the relevant proceedings, we don't get proper initial disclosure, and so on and so forth, and we are not able, therefore, to look properly and assess what the value and strength of these claims is. The learned friend makes all sorts of assertions. They assume, of course, that we are going to end up paying for these claims. if we take the view that actually some of these claims are pretty extraordinary, that these people who buy 4 flats off-placed when they've been told that the whole scheme is dependent upon the process of the developer, and we strongly suspect that in some, at the very least, cases, they are extremely experienced individuals, we rather suspect that exposed to proper court proceedings, we wouldn't see the light of day. Added together to an omnibus claim form, we're left with a juggernaut for which we have to pay. So I don't regard that as a tease at all, my lord. It rather depends upon the assumption being we're going to end up having to pay for this particular matter.
Yes. I mean, it's more a complaint about class actions generally.
Well, my lord, most defendants aren't likely to put their hands up and say, I'd like to be the subject of a class action. That I would accept. But that doesn't mean that if the rules don't allow them, there are genuine disadvantages which go beyond that. But
your point is that there are genuine advantages to the defendant in terms of basically exploring and resisting the detail of the claim, which is much more difficult in the context of this kind of...
That's putting the rather inflammatory point that I made much more shortly and politely, but it is correct, my lord. Yes.
Well, I'm pleased I asked. Anything else? Thank you very much. So...
my lord, I think I may have a right to reply on the ECHR points, just to take to flag one thing in the bundle, which is that the county court limit point I take from my learned friend's own schedule at pages 270, but 671 onwards of the core bundle.
Sorry, which page?
671.
671. Okay.
There you see the total claimed by the claimant. What Mr. Stuart Casey referred to is the mean of those figures. That's completely irrelevant. What's relevant for the county court is how many fall
What is the
within
county court limit? I thought it had all been abolished. What is the county court limit?
It's 100,000. It's in the practice direction 7B.
I haven't. I mean, there's a much more fundamental point. I haven't got page 671 in the core bundle. My core bundle finishes at 660.
That's
and
the
I hate to miss out.
So, my lord, what my lord is missing is the supplemental skeleton from my learned friends, and then this schedule, which is the schedule to it. So, if perhaps those can be provided electronically.
Could it be provided electronically? And if you could provide it to Lord Justice Lewison's clerk with the request that she forward it to me personally, that would be incredibly helpful.
The only point is that when one looks at them, there are a few large claims that skew the mean.
Okay. Well, I think that exhausts the right of surrejoinder or whatever it might be.
I have no desire to surrejoinder on anything, let alone that, my lord.
Well, we're going to take time to consider our judgments in this case, which is obviously important and indeed interesting. We're grateful for the arguments that you have all addressed, and to your solicitors. When you get the judgments in draft, will you please make sure that you use them only for the purposes of agreeing an order and the costs. If you can't agree, we will deal with those matters in writing, and if you can't agree the order of submissions, we'll deal with that in writing too, but we encourage you to agree those matters. So thank you all very much.